afternoon and welcome to today's presentation for our Beat Bite session, How to Request Association Counsel Opinions and Handle Requests for Inspection of Association Documents. I am attorney Melissa Francis of Zelmansky, Danner, and Fiorito, and I will be the moderator of this session today. Our presenters today are Richard Wagner, who is a senior associate with our firm with over 45 years of experience, and especially related in community associations, and Brooke M. Jordan, who joined our firm over a year ago, but brings years of real estate and tax experience to our firm. Ms. Jordan and Mr. Wagner work out of our Mount Clemens office, and they will be presenting to you today and can be reached in our Mount Clemens office, and I will give you that information at the end of the presentation. If you have questions, please put those questions in chat, and I will relay them to our presenters. If you are joining us on Facebook, please put your questions in the comments, and Marcia Williams will be relaying those to me so that we can ask our presenters. So without further delay, I will turn this presentation over to Richard so that he can discuss attorney opinion letters.
Okay, good morning, good afternoon, good evening, whenever you get a chance to take a look at our BEAT programs, and we welcome you and look forward to having you attend our functions. I'm coming to you today from a new circumstance. I'm over in the conference room or the east side, which is spacious, can handle like 20 or 30 people. And you might see me look up once in a while because we have like a 70-inch TV screen up there. So it'll be nice for meetings, should any of our boards wish or management wish to come over here and meet with us. We got plenty of room. Okay. So that being said, one other thing though, today is the 35th birthday of my baby twins, Ryan and Justin. So I wanted to at least give them a shout out and happy birthday. Back in the days when we had to do title searches and register of deeds, I used to take them with me, put them up on the counter because you had to look at books for microfiche and call them my paralegals. So anyways, the salutations being out of the way, we're talking today about two different topics that they come up actually more frequently than you may think they do. And we thought it was something that we should point out some very important aspects with reference to legal opinions from counsel, and then also the world famous 2487 requests that everybody's probably familiar with. So what happens when we start out with the issue about an attorney opinion? Well, the board may be discussing something at a meeting and say, well, maybe we should ask the attorney about this, or maybe the management gets confronted with a situation and says, well, maybe I'll call association counsel and see what he or she thinks about that. So you get that phone call, and the initial reaction is generally, this is my impression. Okay, you want to know what I think you should do? This is basically my impression, but this is something that probably takes a little more research. In terms of we need to know more about the facts or the issues or what the documents say, or check with the applicable law or whatever may have happened in terms of the changes to the law. So then I say, why don't you give me a request for an opinion on that? And I've developed even a very short form that basically has 5 things that asks you to provide, the basics of the facts, the issue, who's the parties involved, are there any witnesses, and then attach to it any pictures or documents or something with reference to the matter at hand so that I can give you an opinion that pertains to this particular item. All right. So the next question comes up, though, is why should we seek a legal opinion? Because obviously the 2 things we're talking about today deals with that line item in the budget that's got the little sad face in it. It's talking about legal expenses. Both management and boards of nonprofits really do want to try to keep the clamps on legal expenses, and that's understandable. But the point being is some of these things are so significant, you can't ignore them anymore, and we'll get into the details of that and further on in this discussion. So why do a legal opinion? Well, the legal opinion is going to provide a definite conclusion based upon the facts, the governing documents, and the applicable law as it stands, basically at the time that the issue is presented. Given the legislative history, it could change within the next session of either Congress or the state legislature. But nonetheless, we try to keep track of that. And also the case law. We have an extensive library of case law available where other communities have dealt with this. It's going to basically provide precedent for future issues or in the future when this issue may arise. And it's going to continue to be good law. It's kind of like in court cases, they have what's called stare decisis. In other words, this case has already been decided. This is the way it should have been decided, and this is the way it shall be decided in the future until something changes. If the facts are a little bit different, or you do an amendment to your documents, which both Brooke and I are going to be talking about during this session, or the applicable law changes. It's going to also, and probably one of the most significant things, is going to provide a basis for what's basically known as the business judgment rule. Now, this gets thrown around a lot. People hear about this, but sometimes the boards are not familiar with it and or management is not. So we thought we'd just provide you a little bit of information. Usually the typical case is going to say, well, is there authority for it in the documents, and is the board acting within their jurisdiction under the documents? But it goes to a lot more than that. Most of the court cases that discuss the application of the business judgment rule, they set forth other criteria, and those criteria have typically been codified, and you will see them in the Nonprofit Corporation Act, which is Chapter 450, under 2541, which is the good faith discharge of duties by board members, 2551, which happens to be with deal with the liability sections of board members in terms of them making their decisions, 2553, that pertains to the fact that everything that the board does, and it's reflected in the minutes, it's presumed that basically all the board members and officers that are attending that meeting agree. There's a statutory presumption that it's agreed that you go along with the program, so to speak. So point of reference for those board members or officers that are listening, if you don't agree with it, it's important for you to indicate on the record, I express my objection to this. And so that goes down in the record in terms of your position on the matter. And then there's also the thing to consider under 2554, which basically is a 3-year statute of limitations with reference to the decisions that the board makes. So given that criteria, the board is required to exercise good faith judgment, do due diligence, investigate the facts, consult with their experts, whether it's their accountant, their attorney, their property manager, or the vendor or engineer. Get as much information as you can and kind of mull it over and then come to a decision in the best interest of the association so that you really base your decision on an informed decision with all the sources that you have available to you. So typically, if you proceed with all that, a court is not going to basically interfere with the administrative affairs of the board of directors. There's a case that goes way back called Ayers versus Hathaway, which set the precedent for the fact that courts don't want to micromanage you, all right? And members should not be micromanaging you. They have elected you, and you have the right to make decisions on their behalf. So having an opinion provides consistency in the administration of the association's affairs. I mean, if you have a different membership on the board, then you're going to say, well, do we have any opinions on this from the attorney in terms of what's been decided when this issue came up before? So it gives you some sense of security and consistency. But it basically also shows and requires that the board is investigating and researching the issues to make an informed decision. All right. So on our next slide there, Mel, thank you. So what should the association provide to the attorney with reference to consider drafting an opinion? Well, as I mentioned before, for one thing, they need to have the copy of the documents, governing documents, if it's not already in their possession. So you should always make sure any amendments that you do, if not already in your counsel's possession or your new counsel or whatever happens, make sure that the up-to-date documents are in possession. Plus, not only that, there's a duty to maintain current documents under the Michigan Condominium Act. All right. So What you want to know is a description of the facts as you've known or as you believe. Try to be as complete as possible, but try to be succinct. I mean, don't go on with a lot of nuances, but just A, B, C, D, this is what's going on. From there, you want to make sure that you have copies of any relevant communications, letters or emails or photographs. Take a picture. This is their yard. We want an opinion as to how this, which bylaws does this violate, so on and so forth. Do you have any statements of witnesses or third parties? Any relevant reports that are made by police, fire, or EMS personnel? Do you have police reports? That's something that's important too. They may be redacted, but at least we've got some information there. And if you can't get them, then you can request that your attorney assist you in obtaining them. All right. Copies of any vendor or contractor opinions, any bids or proposals that are relevant to the subject of the opinion letter. So when I say, okay, wait a minute, you're going to do what? And all right, why are you doing this? Well, our contractor, who basically specializes in this, has basically recommended that we adopt this system instead of the way it used to work. It's going to be more efficient. It's going to be more economical. I had to issue an opinion in one where they had a fountain and the management company wanted to change the operation of their fountain because they had huge water and electric bills, and they came up with a new design that was going to like recycle and reutilize the same water, so the water bills got cut. So it's always important to get input from whoever you're utilizing in terms of a contractor. All right, and if you do have any opinions or reports from other experts, your CPA, your engineer, whatever, please try to include those. All right, so then on the next slide. So how should the association utilize the opinion letter? Well, what's really important is that each individual board member, it's your responsibility. Remember, we're talking about breach of fiduciary responsibility and being protected by the business judgment rule. Every board member should review it, all right? And go to the meeting prepared. I know you don't make a whole lot of money in this job, but nonetheless, you do have a duty to try and be prepared. And then you all get together and say, did everybody get a copy of the opinion? Yes. What do you think about it? So you collectively discuss it at a board meeting. All right. If there's some things that you don't understand about it, or you've got some questions or request clarification of the points from the attorney or the engineer or even the CPA, then don't hesitate to ask the questions. Either reach out yourself or have your managing agent, but make sure that you're clear and consistent in terms of what it is that you want clarification on. Consult with your property manager if necessary. Frequently, they have a lot of experience because they handle many communities. So they can say, they may even offer, you know what, we did this over in this other community and it worked very well. So their input is extremely important. All right. Board members should discuss the opinion and decide whether or not they want to say, okay, we agree, this is it, this is our bottom line, and we're going to go ahead and follow it. And then you can indicate any controversy. I mean, I can't stop somebody from filing a lawsuit. It only takes $175 or whatever. But you can at least indicate to the court that I've done my due diligence, I've done my investigation, I've asked for opinion of counsel, and we are relying on the opinion of counsel. That's why we made the decision we did. The other important thing, and I find this a lot, what's happened in the last 3 or 4 decades of my experience, is nobody seems to keep track of these things. You should always try to keep track of especially your important opinions from your accountants or your attorneys or whatever, and store it for future use. That way, if the issue comes up, you can say, well, we had an opinion on this. I can't tell you how many times from a lot of the associations I've represented for decades, I say, you know what, I gave you an opinion about windows in 2013. Okay, let me pull that up and I'll shoot it on over to you, because unless anything else has changed, that's still going to stand. Okay. What's also important is you're running a corporation here, and there's an attorney-client relationship with the association in terms of the board of directors, who is the administrator of the affairs, either under Section 60 of the Act or at least in the documentation and HOA. You shouldn't be freely giving that out to people because of the fact that it may have a tendency to uh, cause a lot of problems in the community. Keep it in the board. It's kind of like the Las Vegas rule. All right. If it comes up, there's other ways that a member of the community can obtain some of these things. Some attorney-client information the courts will not allow to be divulged because, again, under the business judgment rule, they're not going to interfere with the day-to-day decision-making or the executive decision-making of a board. So there are ways to obtain some of this information, but it's under possibly the protection of a court in terms of whatever circumstance is in dispute, so to speak, in terms of what the attorney says. Okay, so on the next page, then what do you do once you get the opinion? Oh, okay. We've got a little more in our outline than Melissa had at the time we tended this over to her. So there was an opportunity for Brooke and I to work on this some more. So the point being is you're going to make a decision based on this opinion, and whether you agree or not with the opinion, you should at least stay consistent and follow the opinion, because that's going to be the basis of your defense for any action that happens. And again, if you disagree, then you should make sure that you reflect it in the minutes of the corporation. Now, one of the big issues that comes up is, what about attorney opinion and their costs? Well, I don't know if some of you are old enough to remember that old oil filter commercials like pay me a little now or a lot later. It's a lot easier and less expensive in the long run for you to get a decision from your counsel who may be called upon to justify or validate the action that you've elected to take based upon the opinion that has been rendered for it. So I know property managers and board members want to keep the assessments as low as possible. But the bottom line happens to be is you could spend a little bit now for a few hours time versus thousands of dollars, whether it's being just in paying the attorney or even paying the deductible on an insurance claim. It's going to make a big difference. That's why you have to go along with a proposition like, it's really worth it. This is something we need, especially if it's a very controversial issue. Sometimes you'll see in the community, some people want this, some people want that. We used to call them the innies and the outies. You want to make sure that you have something that substantiates your position under your administration. And there's no longer options on a lot of expenses. It used to be, well, we really can't afford this anymore because our line item doesn't include it. But you've got to look at amending your documents. You've got to look at doing reserve studies and perhaps engineering studies. You can't administer the community helter-skelter. You can't fly by the seat of your pants. Since 2014 and 2015, with the state changes in state and federal law, you have to act more like a corporation because you are a corporation. And your failure to do that and observe the requirements or the criteria in terms of exercising your fiduciary responsibility is the possibility that you're not going to be able to avail yourself of the business judgment rule. So that's why I think it's extremely important. I know it's costly sometimes. Sometimes it's not, though. Sometimes it's only a couple hours time, but it's the value of it far outweighs the cost. And in that regard, I would suggest to most associations that if you've got an issue that you know is going to be a problem in the community, you've got an issue that you know is going to come up again, time and time again, maybe you need to amend your documents to like address this issue. Let's put it to bed now. Okay, so we don't have to keep running back to the attorney or other people in terms of trying to make a decision. And go ahead and make the request for an opinion. It certainly makes a lot of sense. And like I said, it's going to save you a lot of money in the long run. With that, are there any questions from Marcia or Mel about opinions? Primarily, the opinion letter takeaways is the idea in terms of what the value is and what the issues are. So that being said, we're now going to turn it over to a very meaty subject that we know probably comes up a lot more frequently then people know about. I mean, you get this little note slid under the door if you're a board member that at 9 o'clock in the morning, I'm going to show up and I want you to show me every check you've written for whatever expense for the last 20 years that I've lived here. All right, so what happens when you get a request for inspection of association documents? Ms. Jordan, would you care to address this, please?
Hi, thank you for joining us today. The sources for a member's request to inspect documents are both the condominium associations and the homeowner associations are nonprofit organizations that are governed by the Michigan Nonprofit Corporation Act, which is MCL 450.2485 and MCL 450.2487. Condominium associations are also governed by the Michigan Condominium Act at MCL 559.157. There is not a corollary act that governs homeowners associations. Homeowners associations are also governed by their declaration of covenants and restrictions, their bylaws, their rules and regulations, procedures and resolutions, whereas condominium associations are governed by their master deed, their bylaws, and their rules and regulations, procedures and resolutions. So who can request to inspect the association's documents? You must be a member to request access to the documents. The association can request, if they don't already have in hand, evidence of ownership, for example, a deed or a land contract. The member should be in good standing. Oftentimes your governing documents define that term, which can prove to be incredibly helpful to the association in narrowing these requests. Some examples are that the member is current in their assessments, they're compliant with the bylaws, they've completed and they've submitted their designation of voting representative forms. And now, if the requester is not the member, but rather the attorney for the member or an agent of the member, the Nonprofit Corporation Act requires that there be a power of attorney or a written consent or authorization from the member to act on behalf of the member. Interestingly, the Michigan Condominium Act does not have a similar requirement, but if your documents do not contain such a requirement, they should, because you want to know that the person actually has authority to access this information. Okay, then on the next slide, what documents and records can be requested for inspection? Okay, what a member is entitled to inspect is a member's list, but the association should be careful in that this list does not include email addresses or information. Emails require consent pursuant to MCL 450.2406A. It should not include a member's medical emergency contact person, employee records, including salary or benefits. It should not include the co-owner's financial information, such as a credit card or an ACH form. Also, the association is not required to turn over payment ledgers of any other co-owner or information about which co-owners may be in delinquent status. Should a member request information about other members that are in delinquent status, the association can provide a total number of residents that are in delinquent status and the total amount in delinquent status, just not provide information specifically as to who is delinquent. Finally, the association should warn the member when providing this list that it cannot be used for commercial purposes or solicitation. For example, selling beauty care products or to compile a mailing list for supporting a politician. Okay. Now, books and records of the corporation. This is defined differently with regard to the Michigan Nonprofit Act versus the Michigan Condominium Act. For the Michigan Nonprofit Act, it serves to narrow the scope of what a member can request. Pursuant to 2485, this means books, records, minutes of the board meetings or member meetings and member list. Per 2487, this also includes the balance sheet, the financial status, and the source of income and expenses. In contrast, the Michigan Condominium Act is not so limiting. This is yet another reason to amend your documents, because per the Michigan Condo Act, this also can include the books, records, contracts, and financial statements of the association. One question often posed is, a member may request the association to turn over any executed contracts that it entered. And they also sometimes, the member also wants to see any bids that were submitted for purposes of deciding which contract to go with. An association may have to turn over the executed contracts, but not necessarily any of the bids or the proposals received. And in general, as Richard was saying, the members elect the board and the board enters into the contract. So board members are entitled to the presumption that they were acting in good faith. They exercise due diligence in their investigation and in their review of potential contractors and relied on experts, the relevant experts, whether that be the attorney, the engineer, or a CPA for purposes of selecting their contractor. And neither the court nor a member should second guess that decision. However, a member can be entitled to the bids as well if that member can demonstrate good cause for the request. An example of good cause would be the member is alleging that there's inside dealing or a conflict of interest that is going on. For example, a member alleges that the vendor that was chosen is actually a subsidiary of the property manager, or the contractor is a family member of a director. In those instances, this information should be disclosed. Another instance where the information should not be disclosed is if it's privileged. The documents involve ongoing litigation. In general, attorney and client discussions are privileged and not accessible to members. Okay, so now, if the member complies with requirements stated so far, then this is prima facie that the request is appropriate. The corporation then has the burden of proof to establish that the inspection is for an improper purpose. The records sought are not directly connected with the person's purpose or other permitted reason for denial pursuant to Section 487(7). A couple of examples of improper purpose would be a member requests, again, a list for purposes of solicitation or commercial purposes to sell Mary Kay products, or for purposes of harassing a co-owner or discriminating or embarrassing another co-owner. Another example would be a member wants to access not just the contracts, but the bids as well, because he has a cousin who also wants to submit a bid and he wants to be able to know what the lowest bid that was recently received, and perhaps he can undercut it. An example of a proper purpose would be the member wants to know what the financial stability of the association is. Does it have enough money on hand to cover ongoing expenses, including maintenance? Or if it has sufficient reserves and income for big projects, such as a roof, especially if the association's infrastructure is older. The member may want to try to understand whether or not there may be a special assessment required in the near future. So for those reasons, that information would be provided. But the request, importantly, must be limited in time to when the person who is requesting was a member of the association. So for example, a person became a resident of the association 2 years ago, but he is requesting receipts from the last 5 years. This request would be denied because that information is privileged. It would be denied as to the 3 years that he was not a member. Okay, then the next thing is the location where the book, where, thank you, Melissa, for flipping that. Where can the documents be inspected? At the location where the books and records are kept, or a convenient place as directed by the board of directors. Some specific examples is if the association is self-managed, a public place might be a good place to do this, because such as a library, so as to avoid any confrontations. If the association is managed by a property manager, then the office of the property manager would be a great place. And another requirement that it would be done during regular business hours, which we will discuss later in this presentation. Next slide, please. When does the association have to respond to a request for an inspection? An association has 5 days upon receipt of the request to either permit or deny it. Per subsection 3 of MCL 450-2487, if a corporation does not permit an inspection required under subsection 2 within 5 business days after a demand is received under subsection 2, or imposes unreasonable conditions on the inspection, the member may apply to the circuit court for the county in which the principal place of business or registered office of the corporation is located for an order to compel the inspection. Now, because the legislator chose the word permit, not produce, it is of our opinion that this means that within 5 days of receipt of the request, the association must approve, conditionally approve, or deny the member's request to inspect. This does not mean that within 5 days of request, the association must physically produce the requested documents. If the association chooses to approve the request, it should advise when and where the documents will be available for inspection during reasonable business hours. If the association conditionally approves the request, it may require the member to tailor the request to identify exactly what documents he or she wants. Now, if the association denies the request, they must provide an explanation. But importantly, if it is denied, the member can file a motion to compel the inspection. And if the court grants the request, it shall order the corporation to pay the fees and costs, including the attorney's fees, unless the corporation proves it has a reasonable basis in good faith to deny the inspection. Now, if the association does approve the inspection, it should provide a time within 2 weeks. And at this point, we want to define what a business day is. Interestingly, business day is defined in the Michigan Condo Act, but it is not defined in the Michigan Nonprofit Corporation Act. Per the Michigan Condo Act, MCL 559.103, Section 6, a business day is defined as the day of the year excluding a Saturday, a Sunday, or a legal holiday. So what we're looking at here is the business day of the record keeper, not necessarily the requester. Just because the member has a right to inspect, this does not necessarily mean that the member also has a right to unreasonably impose upon or burden the person acting on behalf of the association for purposes of compiling the records and monitoring the inspection. So for example, the member requests an inspection at 7 p.m., but the property manager office closes at 5 p.m. It would not be unreasonable for the property manager to set up a time that's within its working hours. Other considerations is the volume of the request. What documents is the requester requesting? Is it something that the association will have to contact the bank for to obtain the information necessary, or perhaps contact a vendor to obtain invoices? So those sort of considerations need to be looked at for purposes of figuring out how long it will take to produce the documents. Okay, the next slide is the how, please. Now, how should requests to inspect documents be made? The request must be in writing, and it must be delivered to the association at its registered office or its principal place of business. So for example, if the property manager is the association's resident agent, then the member can deliver the written request to the property manager's office. If the association uses its clubhouse as a business office, then the member can deliver it to the clubhouse. But if the association only uses the clubhouse as an amenity, then it is not okay for the member to deliver the request there. In addition, the request must state with reasonable particularity the purpose of the inspection and what records and time period are requested to be inspected. The purpose must be reasonably related to the person's interest as a member. So for example, a member, an African-American man, receives a violation letter for installing cameras on his chimney. The member who's resided in the community for 2 years, he approaches the property manager and requests that he receives copies of every violation letter issued to any co-owner in the last 5 years. His reason is because he's a member and he has a right to know. Initially, the association can deny this request because it's too broad and burdensome, and it's not reasonably related to the member's interest. It could require that the member that the documents produced be restricted in time to within which the co-owner was a resident. So in this situation, 2 years worth of information, not 5 years. The other 3 years constitute privileged information accessible only to members. For it to be reasonably related, he could tailor the request more to say that he would specifically like violation letters that involve cameras on chimneys. And the purpose that he wants it is because he's asserting that the property manager is racially discriminating against him. So to further tailor his request so that certain documents could be released, he could identify other members in the community who are not African American, who also have cameras installed on their chimney, and then he could request all violation letters involving cameras issued to those units in the past 2 years. So again, the association does have the power to limit the date to the time within which the member is a resident, and also the type of violation that was issued, limited to the issue that the member is most concerned with, which is violations for cameras. And the member could also request information as to the results of these violations. Did they end up paying it? Did they remove the cameras? Information of that kind. Now, the cost attributed to these inspections. The Michigan Nonprofit Corporation Act actually allows for reimbursement, whereas the Michigan Condo Act does not require it. Specifically, the Michigan Nonprofit Corporation Act at MCL 450.2487, Section 9B states that the right to inspect records includes the right to copy and make extracts from the records of a corporation, and if reasonable, the right to require the corporation supply copies. The corporation may require the member to pay a reasonable cost for labor and materials for copies provided. Therefore, again, if your documents do not currently provide for this reimbursement, you should amend your documents to provide that a member will have to pay a reasonable cost attributed to the time required of the person who monitors the inspection and compiles the information to be inspected. The board could deny the request for inspection if it determines that the request is not made in good faith. And the Michigan Nonprofit Act provides specific examples in 450.487, Section 7, A through C. If the request impairs the right or the privacy or free association of the members, for example, it's used to gather information to intimidate people or harass people, embarrass them, or for acts of incivility or discrimination. If it impairs the lawful purposes of the corporation, again, if the member is simply attempting to gain a member list for purposes of commercial purposes and soliciting them to purchase their products, or to put together a mailing list to support a politician. It could reject a request that opens lists of donors or donations because providing that information would not be in the best interest of the corporation or the donors to disclose. And finally, they could reject the request if it's based upon mere speculation, idle curiosity, an improper purpose, or bad faith. Again, as Richard said, in general, the courts will not second guess a board's decision. The board is elected by the members, and it's entitled to the benefit of the business judgment rule, that they were acting in good faith and they exercised due diligence, did a thorough investigation, consulted the proper experts, if that be the engineer, an attorney, a CPA, in order to come up with the decision that they did. One thing that the association could do to protect itself, however, is require that the member who is entitled to the inspection sign a confidentiality agreement and/or an indemnification agreement. This means that the member cannot disclose information to anyone who is not a member of the association or a third party not entitled to the documents or information. Okay, for the last slide.
Okay, before we move on, Brooke, we do have a question. The question is, can a text or an email be considered a request delivered in writing?
Ooh, it would have to be delivered to, it said to the place of business. So that again would have to go back to the principal place of business. So if the resident agent is the property manager, then it would have to go to the property manager's office. technically it should go in a writing to the office, not through an email, because who then would you direct it to? Richard, did you want to?
I think I tend to agree. I know a lot of everything is done with email almost anymore, but there needs to be a writing, and sometimes perhaps property managers is busy with a number of things. And not only that, the property manager may not be listed as the resident agent on file with LARA. So the best methodology would be to do a letter in writing, care of the resident agent as specified by LARA. That would be my response on that. I got a couple of other things I'll add on when we get done with some of these questions here, if there are any. Is there anything else immediate here, Mel? Because there's a couple of points I wanted to point out here.
No, that was the only question.
All right. So, Brooke, is there another page for you? I was making some notes and I didn't look where we were in the outline. Is there another page there, Mel?
Is
Okay.
to allow the inspection. It's a balance act here. There is a right of inspection given to association members by common law, Michigan statutory provisions, and association governing documents. Implicit in these rights, however, is that these requests should not be so unnecessarily burdensome, unwielding, or numerous as to impair the operations of the business. I know a lot of associations have a few people that constantly submit requests, and they're not tailored to any specific need or purpose. And it's hard to continue to run the day-to-day business and be responsive to these requests. Again, that's why it's important to ensure that the criteria is laid out in your governing documents as to exactly what is required from a member if they submit a request. I know Richard had something that he wanted to add to this part.
Oh, yeah, there's a couple of things I actually wanted to say. If you know it's going to be a huge controversy, then I would recommend that as for location, maybe you need to do it at the attorney's office so that the attorney can sort through the items in terms of what's going to be released and what's not going to be released. And then again, document what you've given them and document what you've denied them and the reasons therefore. So if called upon in a court to defend the action of the board of directors, there's some basis, or excuse me, some memorialization in terms of what's transpired. Interestingly enough, too, is how many conflicts there are between Section 57 of the Condo Act and the Nonprofit Corporation Act. And the question comes up a lot of times in terms of who's supposed to control. The Condo Act has basically no restrictions. Basically, it says books and records is not defined necessarily, where the Nonprofit Corporation Act has kind of a listing of what you can get and criteria that you need to perform. The basic way that you're going to be able to impress upon the membership which way the chips are going to fall is amend your documents to have an article with reference to when there's a request for inspection of documents, these are the criteria that you need to satisfy. And the reason for that is then you can you have consistency, you've got a guideline, and you can't be accused of things like you're discriminating and everything else, because everybody's treated the same way. No matter what your faith is, your color is, or anything else, these are the criteria you need to see the records, and these are the reasons why in terms of expressing what you want. Interestingly enough, too, is the issue on attorney's fees. A lot of times under Michigan, or at least under Michigan Nonprofit Corporation Act, if the court thinks that the association has not been acting in good faith and requires them to produce the documents, then the co-owner can get their attorney's fees. But what about the condo documents that talk about remedies when a co-owner can sue to enforce the provisions of the documents? And you've got in the remedies section that in no circumstance will a co-owner get any attorney's fees. So now you got a conflict there between the Michigan Nonprofit Corporation Act and the condominium documents that say you can't get attorney's fees. So these are the kinds of things you really need to address with reference to amending your documents, and also, again, do it at the attorney's office. One other thing would be this confidentiality thing. If you know there's going to be a huge controversy, you may want to put that in as part of your criteria in the bylaws. The court will look at the fact that the majority of the co-owners have adopted these bylaws and expect everybody to live by these bylaws. So if you put that criteria in, then the courts are going to lean towards enforcing the condo documents as written, because it's not just the competition between the member and the board. It's what the people of the community have decided. I cannot overemphasize, though, that courts are lean heavily towards transparency and towards allowing members to look at the documents, sometimes regardless of the method and manner. A very recent case that just came out this last week. Basically, there were a co-owner that wanted to look at the documents. It was very vague what they stated they wanted. It wasn't really clear. When the board denied them, the members sued the association and the board and put a lot more detail into the complaint with reference of what they wanted and why they wanted it, because obviously somebody helped them probably style the complaint. The court, when it went up to the Court of Appeals, basically they said, well, even though he didn't comply with it to begin with, he did say a lot more in his complaint that he filed. So we're going to send this matter back to the trial court to find out whether or not the member who requested these documents stated a proper purpose and asked for documents that were reasonably related to his proper purpose. So even though the format was not followed exactly, or was kind of vague, or in fact burdensome, the Court of Appeals mentioned that it wasn't the best way to request things. They went ahead and upheld, or at least sent it back to the trial court to ascertain whether or not to allow the documents to be released to them. So I think sometimes this is going to be an issue that you need to discuss with your counsel. And it's, again, like many situations that confront associations, they're fact-driven. Why they want this, why they think they need to have it. As Brooke has said, it can't be mere speculation, but there are courts that say, well, he's a member, he should get to look at the documents. So in that event, too, you're going to want your attorney to be able to ask for guidance, direction, and some definition by virtue of protection order in reference to what it is they want, or at least forcing the member to be more specific about what they want and why they want it. And this way you can hopefully fend off things that are just very adverse for the association, especially in terms of spending legal fees, constantly back and forth with constant requests and requirements. Maybe you want to put a limitation on it. Somebody who constantly repeats things, requests, not more than one list every 90 days or something, or immediately upon some controversial expenditure. I don't know, but it's something you can discuss with your attorney in terms that's going to fit your circumstance, and it may be documented by amending your documents.
Richard, for the audience, could you provide the name of the case that you were talking about, the Court of Appeals case?
I just printed it out. The question was whether I put it in this file or it's in the back room here. Oh.
Was it the Barfna versus Echo Valley case?
That's it, right. It's Echo
Okay.
Valley. I'm sorry. Thank you, Melissa. Yeah, it's kind of
welcome.
the world famous Echo Valley case. They were Echo Valley was the condominium that was involved in the smoking dispute and things like that. So now they're involved in a request for documents dispute. And thank you very much, Melissa.
Yeah, I just wanted to clarify that was the case that you were discussing.
Yeah. Yes. Just released, I think, a few last week or whatever it was. This past week. Any other questions? We threw a lot at you. What's interesting is the difference between the Condo Act and the Nonprofit Corporation Act. Somehow you have to balance. A court's going to be required to try to balance these equities or these interests. But nonetheless, I believe it best to have something in the documents to show consistency and also fair treatment of everyone. So you don't get into these arguments, well, you didn't give them to me because. No, everybody has to do this. And, you're just trying to rile up information. Financial circumstances, I think, are going to be looked at a lot more seriously by courts, because they do all the way back to common law. And there's an early 1908 case that I pulled that I was reading. Basically, investors in a bank enterprise who took over one of their defaulting uh, uh, customers. Financial circumstances, the courts are going to be a little more liberal in allowing uh, members to look at the documents in terms of how money is spent, uh, taken in and spent, and for what purpose. So that one, I think, is pretty important. But other than that, I think you need to adopt some criteria. Anything else we can help you with?
Yep. What additional do you have any additional takeaways for this section of the presentation?
Well, again, I think it's very important to look at your documents to see whether you have something to address these circumstances. So you're always talking about amending your documents. And in general, the recommendation is since 2014, 2015, every community should be amending their documents to address this and other situations that have occurred. I think Brooke brought up a very good point that the definition of business days exists in the Condo Act. When you look at 450.2105 on definitions in the Nonprofit Corporation Act, it has no definition of business days. All right. So again, the court's going to get hit with it. And probably if they get an attorney that knows something in this area, they're going to ask for the requests under both authorities one way or another. And will probably typically or should typically try to comply with the Michigan Nonprofit Corporation Act. And I think that's going to be the issue in terms of where the court leans, is how they fashion their requests. I know that there are some courts that have held, and I know that there are some attorneys that their position saying you must produce the documents within 5 days. But when you look at the dictionary definitions of permit, either with Webster's or Black's Law Dictionary, it talks about to allow or consent to permit. Had the legislature intended that you have to physically produce the documents in 5 days, they would have said produce the documents within 5 days, because there's all these other circumstances. Could be closed for the holidays. It could be a voluminous request. It could be you have to go to other sources for records. So I think it's safe, but I do believe you need to give some kind of response within the 5 days. In other words, we're going to, like Brooke said, we're going to allow it, we're going to conditionally allow it, or we're going to deny it, and this is the reason why. At least start the process. It's almost like the interactive process with reference to discrimination complaints. There has to be an exchange of information between the board and the member in terms of what it is they're looking for and the purpose for it. So I think that's about it.
Are there any additional questions for our panelists? I don't see anything in Zoom at the moment. However, if you have a question, please chat it to me and I will be happy to get it to our panelists. If you're on Facebook, please put it in the comment section and Ms. Williams will get that to me.
Okay. Is there anything in here?
And it does not appear that we have any other questions in the Zoom chat. And Marcia has advised there are no questions on Facebook.
Okay.
So I would like to mention again the Michigan Legislative Action Committee of CAI, which Gregory J. Fiorito, one of the partners here at our firm, is the co-chair of. The Legislative Action Committee is currently working with the Michigan Legislature on the amendments to the Michigan Record Title Act, and there are other pieces of legislation that are up that they are working on, and they are also involved in working on national legislation. So if you are interested in helping them with that cause, you can visit the website that is on the bottom of this slide. Or if there are issues that you would like to see legislation enacted, you can also send them message, and they can work on seeing if that is a feasible piece of legislation or not. If you have questions for Mr. Wagner or Ms. Jordan after this presentation has ended, they can both be reached by phone at 586-465-1330, as they are, again, both in our Mount Clemens office. Mr. Wagner can be reached by email at rwagner@zdfattorneys.com, and Ms. Jordan can be reached by email at bjordan@zdfattorneys.com. If you would like a copy of this presentation, I will stay on the Zoom for a few moments. You can put your email address in the chat, and I will send that when the presentation is concluded. Or if you decide later that you would like it, you can email me at mfrancis@zdfattorneys.com. And next month, we are going to turn to another area of our practice on December 15th at noon. Tracy Danner Bond and I will be presenting our beat on estate planning and why it is important for everyone to have an estate plan. So please mark that on your calendar, December 15th, and we will, we will see you then. So have a great afternoon. Thank you for spending your lunch hour with us. Visit our website, zdfattorneys.com, and you can always visit us on social media. If you would like to view this presentation or any of our past presentations, they are available on our YouTube channel, which is ZDF Condo. So again, have a great day, and thank you very much.